Hi, I'm Elizabeth de Stadler and I work for a small consultancy called Novation Consulting. We like to refer to ourselves as rehabilitated attorneys, which means that we put the human back into compliance and risk management. Lately, not at all surprisingly, we've had to focus a lot on data privacy and information governance because that seems to be the hot topic globally at the moment. So how I became interested in data privacy in the first place is years and years ago. I was giving a lot of advice in the media industries, and what was happening a lot was people were asking me questions about direct marketing, and back then all we had was the Consumer Protection Act, and you could basically spam everybody silly as long as once they unsubscribe you listen to them, in a nutshell. And then about, I think now 10 years ago, which is about as far back as my memory can go, Parliament passed a piece of legislation called the Protection of Personal Information Act, which changed the way in which South African companies have to think about direct marketing, because it switched us from an opt-out country to an opt-in country, except for the fact that POPI never quite came into effect. So while the law was signed in, I think, 2012, what has happened up until now is that the president hasn't yet given us a date for POPI to become effective. But it doesn't mean that nothing has happened. So we have an information regulator. Her name is Advocate Pansi Klakula. And that was a really good appointment. She was the rapporteur for data privacy for the African Union for many years. And so she comes with quite a lot of rich background knowledge about this. She's just been appointed to a UN Committee for Human Rights, which will also be looking at data privacy. And the most sort of recent news out of her office is that they've just appointed a chief executive officer, they've appointed a chief financial officer, and they are about to appoint their senior sort of advisor on policy and IT related issues. So stuff's happening, but POPI's not in effect yet. So why I have a job in information governance or in privacy, even though there's no South African regulation, is, in a nutshell, I think that it's just good business. So if you look at studies that are done, the big one is by IBM. Every single year they do a study about the cost of data breaches to companies. If I translated that into rand value, last year's study showed that a data breach will cost your company about 36.9 million rand. And very little of that is made up out of fines by regulators, etc. So one of the most famous breaches, if you really want to learn about the anatomy of a data breach, what goes wrong in data privacy, you can look at a breach that happened at an American retailer called Target, which I think we can all agree is a phenomenally stupid name. They have a bullseye for a logo as well. So it's like an open invitation. Please target us. So what happened to them was their point of sale system, so where you swipe your credit card, got hacked. And a whole bunch of credit card records ended up online, completely identifiable, unmasked, etc. And you can imagine what happened. There was a lot of fraud, etc. That breach cost Target, to date, I think $270 million. And if you look at what that cost is comprised of, it's in the immediate aftermath of that particular data breach, their sales dropped by 34%, which was horrible because it was Christmas, right? So they lost a whole lot of money. They lost a lot of goodwill almost permanently. Their chief information officer got fired, their CEO got fired, and that kind of staff turnover costs you a lot in productivity. They had to pay a whole bunch of lawyers. So as Shakespeare said, first kill the lawyers, right? So that would have saved them quite a bit of money, I reckon. And then also, you know, what tends to happen, apart from the fact that you lose customers that you have to get back, it always costs you quite a lot of money to fix what was wrong in the first place, and now you have to do it while you are being scrutinized from all angles. And so in the end, because America doesn't have really any federal privacy laws, nothing of that $270 million was made up of fines. I think they were fined $250,000 by the FTC, which I'm bad at math, but I mean that's a fairly low percentage of the total cost. And so we often have to help clients with data breaches in South Africa. POPI who gives a shit? I really don't care about legislation. I think it's a phenomenally bad reason to do anything. If you are going to spend some time thinking about how you treat your customer or your employee information, think about it in terms of all of the other kinds of risk that you are creating by not being careful with that data. So if we had to bring it back to South Africa for the moment, I mean, we can't ignore the fact that this piece of legislation is coming. So POPI is coming, or papaya as they make me call it, which I think is only funny when you say stuff like, when will the papaya strike the fan? And the good news is that we're not the first country to do this, and also, you know, we have a lot of sort of foreign examples that we can look at. POPI was based on the GDPR, or the GDPR's predecessor. The GDPR, for those of you who have not been following it in the news, is the General Data Protection Regulation, which is the much talked about regulation that came into force, I think it was last year, May, in the European Union. The first GDPR fines have just started trickling through. So the first company to get a fine was Google. They got fined $50 million for a bad privacy notice, basically. I don't mind admitting that for a very long time we listed Google's privacy notice as one of our favorites. It was in plain language, and there were lots of aids to understanding. There were a couple of fairly good videos, but what the French regulator said, well, it doesn't matter how good it is if you have like 118 pages worth of privacy notice and you hide the important stuff, which in this case was how do I set my preferences so that I don't get personalized ads popping up. If you've hidden it in a lot of information, that's not good enough. So they were the first people to get fined. Just in the last 2 weeks, the UK Information Commissioner's Office, which is headed up by Elizabeth Denham, who's my second favorite Elizabeth, they indicated that they are thinking of fining British Airways €183 million. On the same day or the next day, they said, well, we're going to fine Marriott, the hotel group, another €90 million. So those fines are big. By comparison, the POPI fines are small. It's 10 million rand per sort of prohibited conduct. So there's a big difference between the two. But otherwise, I would say if you comply with the GDPR, you're about 85% compliant with POPI. It doesn't work in the other direction. So if you're POPI compliant, I would say you're slightly less GDPR compliant, because oddly POPI is stricter on certain things. So POPI, for instance, is very strict on where you can get your information from. So I'm not an alarmist person. I don't easily tell companies to be worried, but if you are in a business that is in data cleaning, data enrichment, if you are buying and selling leads, if you are scraping the internet for information which you then commoditize, you should be very, very worried. That business model is about to go out of fashion if it hasn't already. So these two are very closely aligned, which is fantastic because it means that we can look at what's happening in Europe as trends. And one of the big sort of global trends now is that one after the other countries are passing GDPR-like legislation. Last week it was Brazil. There are multiple countries in Africa considering it at the moment. So for companies that do cross-border trade, that's also good news because there's a bit of standardization happening. So one of the reasons why we, for instance, been doing this for the better part of a decade is a lot of South African companies have proactively become compliant with legislation such as the GDPR, particularly if they have European clients. Now, let's say I'm a South African IT company and I have clients in Europe and my service requires them to send data to me in South Africa, and this is the same for all data protection legislation. Before you can send data out of the country, you have to make sure that the country that you're sending it to, that it'll be protected there. And if there isn't a law that will protect it, you have to conclude a contract usually that says, well, I'm going to send this data to you, but you will apply the GDPR to it. So a lot of South African companies are not, even though they're not directly under the GDPR, are being put under sort of the commercial force to comply with the GDPR proactively. Some South African companies are actually subject to the GDPR. In other words, they can get fined. There's been a massive amount of misinformation about this. It's one of my pet hates, and why I can say it because I am a lawyer. I hate lawyers, is because they have somehow somewhere down the line forgotten that when they give advice they should go and read the legislation that they're advising on. Instead now what lawyers do is they Google stuff like all of us, and then you get mistakes like you have to comply with the GDPR if you have the data of European citizens. That simply isn't true. Otherwise we would all have to comply with the GDPR. For a South African company to be at risk of a fine from a European regulator, you have to be doing something where you are targeting individuals while they are physically in Europe. That's a very sort of oversimplification almost, but so if you are targeting the European market, and you're targeting individuals while they are in Europe, then you may have to comply with the GDPR, otherwise you will face a fine. So one of the other misconceptions that we have to battle all the time is that people think POPI and the GDPR is just about information security, and information security is incredibly important. But more often than not, the breaches are not the result of companies not having a firewall or companies not securing their systems or their networks correctly. A lot of the times, in fact, it doesn't matter whose research you read, about 80% of the time, the breaches are happening because companies are either abusing information, in other words, they're doing stuff with information that isn't strictly speaking allowed, so like selling it, because it's not yours, you can't sell it, or because even though they have good firewalls and good information security generally, people are getting around those safeguards. So we always say, as long as the favorite password on the planet is still 1, 2, 3, 4, 5, 6, you can have the strongest firewall on the planet, people will get around it. And so it's really important to take a step back and think about what are all of the rules that apply because of these pieces of legislation. We talk about something called the information life cycle, right? So information comes into your organization, you do stuff with it. At some point you're done with what you're doing and you make a decision either to keep it or to get rid of it, although that last bit is very hypothetical, no one does. And throughout that life cycle you're supposed to secure it. So keep it confidential, make sure that its integrity is protected. Integrity is that thing that makes, if someone hacks a bank, they shouldn't be able to change their bank balance. That's integrity. How do I make sure that there isn't unauthorized sort of changes or manipulations of the data? And then the other thing is availability. So how do I make sure if my building burns down tomorrow, I still have access to the information that I need to do my job? And that CIA triad, they call it, is all around this information life cycle. So if I had to say in a nutshell, what are the rules for the information life cycle that POPI and the GDPR prescribes? It looks at where can you get information. So is it okay to scrape the internet and then do whatever you like with that information? Categorically no, it's not okay. Just because it's in the public domain doesn't mean it's not personal information. It's still subject to this legislation. It then looks at making sure that people are transparent with what they do with information. It looks at things like what can and can't you do with information. So one of the things that POPI, for instance, is quite clear on is you can't send unsolicited email to a person without asking their permission first. And then it looks at how long can you keep information for. And the answer to that is basically, I can find an operational reason to keep information. You almost reverse engineer it. But there's some information that you want to keep longer than the rest. But if I had to say it in a sentence, less is more. So find the most minimal way of processing information to still achieve what it is that your business wants to achieve. Less is more. Collect less, keep less, do as little as possible with it, give as few as possible people access to it. As long as you apply that principle consistently, the chances that there are some big sort of unknown risks in the business becomes exponentially lower. We often get asked, what should we be doing right now? So the first thing is stop panicking. And a lot of the panic in South Africa currently is being fueled by lawyers. Again, there seems to be a trend here, a golden thread. Lawyers are twits. If you get these emails, as I do almost every day, come to our workshop, POPI's going to come into effect in 2019, that's an abject lie. You should report them to, what is the Advertising Standards Association, is now called the Advertising Regulatory Board, or ARB. That's a bit of a, anyway. So you should report them to ARB. There are things that you can do to prepare. So one of the things that the regulator actually requires is that you at least have a plan. It's called a POPI compliance framework. And usually these frameworks have a particular structure. So firstly, you look at internally who are the people who are going to be responsible for information governance and privacy in your business, and it's good practice to appoint a team. And there's a chief information officer usually, or an information officer. That is automatically your CEO. They are very bad at being information officers, so you should delegate that authority to someone. The second thing that we always look at is, are your policies up to standard? So policies are those documents, it's where information goes to die, but they're still really important, because if you don't have the policies, essentially what it means is that you don't have an agreed way of working with information, or for anything else for that matter. And what it does is, when something does go wrong, it makes it very, very difficult to figure out what the root cause was. So look at your policies. If you have the right policies, which a lot of businesses do, look at whether those policies have actually been implemented. And how you do that is to audit, unfortunately. So to look, are people following this policy? And if they're not, it's usually, and we find that is the case 90% of the time, it's usually because you haven't actually implemented it. Emailing a policy to everybody in the company isn't implementing it. There's usually a very, very good reason why people are not following the policy, and often it's because it's impractical, or because you haven't made the required process changes, or because you haven't given them the tools to comply, or because you haven't given them any training on what a policy means. So often it's in that layer where you find most of the risks. And then obviously sometimes there are risks that you don't have control over. Usually that's when you've gotten another company that with you or for you, they process information, and their contract management is very, very important. A lot of the fines that you see are caused by third parties. So we have a service provider who sends out our bulk email, and they accidentally expose the entire database. So who's responsible? Well, not in South Africa, it won't be the service provider, it'll be you. It's your information, and you have to make sure that you have a contract in place that makes it clear to that service provider that they must put security around that database, for instance. And then lastly, you can look at getting some insurance. So if we circle back to the Target breach, $270 million, their insurance covered $90 million. There's a massive assumption on the part of South African companies that your cyber insurance will cover you fully if you ever get hacked, and that is absolutely not true. If you haven't done the policy work, if you haven't done the training, if you don't have the right processes in place, if you don't have the right contracts in place, they will in fact not cover you. So insurance is always the last thing that you do in order to cover yourself for that bit that you can't control. And the rest is just good housekeeping. We started a hashtag, it's called a complianoscopy. That's when we take a long, hard look at compliance officers and lawyers and all of those in-house people who are often seen as the business prevention unit, and talk about why it is that compliance has gotten such a bad reputation. And one of the reasons I find is because often they are incredibly impractical. So pragmatism for me is the soft skill that you need to successfully implement, compliance strategies around data privacy. So think about things like, not everybody needs training, and they certainly don't need training about the 9 principles of the lawful processing of personal information. No one needs that training. So think about, what do we want people to do differently tomorrow? And if the answer is, we don't want this specific person to do anything differently tomorrow, leave them alone so they can do their jobs and move on to the other people. So the idea of pragmatism is incredibly important. Obviously, this kind of compliance becomes really challenging for small to medium-sized enterprises because it tends to be, or the perception is that it is really expensive. My advice to smaller businesses would be to look at a couple of things first. So firstly, if you are collecting a lot of personal information, there's a lot you can fix by just looking at your forms. So make sure that you're only collecting what you need. Make sure that you have a privacy notice. Rip one off from the internet. There are more than enough good ones. If you do feel like you don't know where to start, go and root around our website. There are some good blogs, some of them are even a little bit funny. There's also a product called POPI DIY, because anybody can. And what that will do is it'll just tell you where to start. And honestly, a lot of this is good common sense, and most of it is just good business.